Thank you. I'd like to move on to the Law Commission's recommendations. As you'll be aware, Minister, the Law Commission produced a series of reports between 2020 and 2021 around enfranchisement, right to manage, common hold, and the price payable on enfranchisement. Why did the government choose not to include the remaining Law Commission recommendations on enfranchisement and the right to manage in this draft bill?
Well, put very simply, because the bill is already very large, includes significant structural changes to the housing market on common hold, on forfeiture, on ground rents, and we can't deliver the whole of the government's common hold and leasehold reform agenda in a single piece of legislation. And as I made clear in my opening statement, there's going to have to be other legislation that brings forward other elements of the reforms we're committed to in our manifesto.
Fair enough. We have heard, though, from many leaseholders about the impact that development value in particular is having on enfranchisement premiums, which they think might be a barrier to converting to common hold for many blocks. Do you think that that is something that could specifically be carved out and addressed in the final bill?
I'm not going to be drawn on whether it will be dealt with in the draft bill. We absolutely recognise the issue here. I think it's probably worth me setting out some of the background and thinking. Obviously, we're already taking steps to make enfranchisement cheaper and easier by implementing the reforms in the 2024 Act. I'm sure we'll come to that as a separate issue. We obviously understand that in some cases development value can make the cost of buying a freehold prohibitively high. It's really worth having a look at what the Law Commission said on this point. In its valuation report, it proposed a sub-option to enable leaseholders to voluntarily agree to a restriction on future development of their property to avoid paying development value as part of the collective enfranchisement claim. But as the Law Commission noted in their own report, there's some quite challenging practical and legal difficulties to implementing this. So we are giving it consideration, we are keeping it under review, and we'll obviously listen carefully to what the committee responds to, but I recognise the challenge. I think there are a number of ways that the problem might be approached.
Turning to the right to manage, I think you've already said that you want to produce separate primary legislation on the right to manage for common hold, leasehold and freehold homes on private estates. Is that work that's already underway now? Are the Law Commission working on a draft bill for you at the moment on that?
We bring officials in on the Law Commission. I should declare an interest, by the way, Chair, that my wife is Joint Chief Executive of the Law Commission. Sorry.
We have asked the Law Commission to look at this issue, so they're not working on a draft bill, but they are working on recommendations on how we would tackle this issue. So we're not at draft bill stage yet on it.
Okay, and is the timescales for that, does that align with the timescales for this Parliament? Is it likely that those recommendations will be delivered in time for you to get an Act passed before the end of this Parliament?
We intend to honour our manifesto commitments in this Parliament, as I made clear.
Okay. I would just add that the project that the Law Commission has included in its 14th programme is looking at sort of right to manage in the context of privately managed estates as well, which the Department's supporting, and that supplements the existing work of the Law Commission, and we'll be taking that into account as well.